My name is Robert Eno. I'm the Registrar of the African Court on Human and People's Rights. African leaders thought that one way to enhance the protection of human rights on the continent was to establish a court that will give legally binding judgments, not recommendations as the Commission was doing. Even though the protocol provides for access to justice at the international level, it also curtails the extent to which one can access this justice. One, by ensuring that states ratify the protocol in the first place, but secondly, and more importantly, by requiring states to make a declaration if they want individuals and NGOs to bring cases against them. In my view, this is limiting access to justice. So far, while we have 33 countries that have ratified the protocol, only 8 have deposited the declaration. The number of states that have deposited the declaration would have been 12, but 4 countries that had deposited the declaration decided to withdraw. The court is actually engaging with those states that have withdrawn, because at times it may just be out of ignorance. They may not understand properly the functioning of the court. The few states that we have engaged so far are showing very positive signs that they are going to reconsider the decision that they took. If you look at the court's jurisprudence, we've developed jurisprudence on the right to fair trial and on access to justice. In particular, the court has ruled that the right to legal representation is a very important element for fair trial, and of course, to ensure that you have proper access to justice. The court itself has taken the initiative to institute a legal aid scheme where we provide legal aid to indigent applicants that appear before the court. The African Union has adopted a legal aid scheme. Unfortunately, that legal aid scheme has not started functioning. So we are hoping that within the next few years, the legal aid scheme of the African Union will be up and running, and we'll have a viable legal aid program to provide legal aid and enhance access to justice, not only for the African court, but for other African Union human rights bodies like the African Commission and the Committee of Experts on the Rights and Welfare of the Child. We have developed an electronic case management system. You can do e-filing from wherever you are. You can follow developments of that case electronically to know the status of your case without necessarily leaving your country. So we are hoping that this system will become operational sometime early next year. We are also instituting an online human rights program for domestic judges, where we'll be training domestic judges on the African human rights system in general, but also on the jurisprudence of the African court in particular. We are also ensuring that lawyers, when they go before domestic courts, can also cite cases of the African court, decisions of the African Commission or the African Committee before judges at the domestic level, to ensure that our jurisprudence is not only meant at the international level, but can also be used at the domestic level. For the first time, we had a tripartite dialogue between the ECOWAS Court of Justice, the East African Court of Justice, and the African Court on Human and People's Rights in June this year, where we spoke on a wide range of issues, including how to promote access to the different courts, to enhance the better administration of justice on the continent. If we want to succeed in seeing the Africa we want in 2063, then we must put human rights at the center of everything that we do. Our leaders, citizens, NGOs, the academia, the private sector, we must know that the promotion, protection, and enjoyment of human rights is our collective responsibility.